Yes, we are live now. Just please proceed.
So, are we audible to you?
Yes.
So, if we may have your permission, maybe start with the session.
Yes, please.
Thank you. Thank you so much. We gather here today to hold discussions on a very apposite topic. It is something that has far reaching effects on all of us as individuals and the society en masse, either directly or indirectly, considering the digital age we live in. Social media and OTT platforms need no introduction these days. It won't be much of a stretch to say that they belong to the category of one of those few things that no one is totally unaware of. They are present everywhere. Every nook and corner of the society has had at least a taste of them. With the pandemic and the resulting quarantine, the internet has only been the form of communication and connection between people. Studies have even shown a strong growth increase in its usage ever since last year with the oncoming of the pandemic, which continues to grow by many folds each day. However, there is also the advent of the evil in equal parts with the good, if not more, which rattles the authorities enough to make a move on it. Good evening, everyone. I, Pratishtha, a member of the seminar committee of RMLNLU, extends a warm welcome to all present here. The session today is about the tussle between central government and digital media platforms in lieu of the Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules of 2021. The Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules of 2021 were released by the Ministry of Electronics and Information Technology in February. Social media intermediaries were given a 3-month period to comply with the new rules. The government on 26th May issued a fresh notice to all social media intermediaries seeking details on the status of compliance with the new rules that came into effect on that day. This move by the government has met with a lot of criticism and accusations of subverting the values entrenched in the Constitution of India. Concerned individuals and organizations regard it as an attack and fear its consequence on online privacy, freedom of speech and expression, and access to information. Twitter sought an extension of the compliance window and called for a constructive dialogue and collaborative approach from the government to safeguard freedom of expression of the public. WhatsApp also filed a case in the Delhi High Court against the government on ground that the new rules violated customer privacy. The new intermediary guidelines and digital media ethics code have also been challenged by entities like The Wire, LiveLaw, and The Quint. Meanwhile, the government has maintained its position and clarified that these rules permit social media platforms to operate in India freely, but with due accordance to the law. Every entity has to abide by the constitution of the country and the rule of law. Also, as per Article 19 of the Constitution, right to freedom of speech and expression is not absolute and is subject to reasonable restrictions, especially in case of threat to national sovereignty and security. The strong arguments on both sides have since created a space for debate and resulted in a war of words, precisely something which the session today will tap upon. For a more inordinate parley, we have invited an eminent personality, Dr. Amar Patnaik, as the honorary guest speaker, who with his vast experience and knowledge will surely throw more light on the subject and help us understand better the intricacies of the topic and leave us with more awareness. Sir is an elected member of the Parliament of India, representing Odisha in the Rajya Sabha, and stands as the General Secretary of the Biju Janata Dal Party Parliamentary Party Office and is also the current head of the party's IT cell. He is a public intellectual and was an Indian Audit and Account Service Officer and Principal Accountant General of Sikkim, Odisha, West Bengal, and Kerala. He was appointed as a member of Joint Parliamentary Committee on Personal Data Protection Bill and as an ad hoc member of the Committee of the Rajya Sabha to study the alarming issue of pornography on social media and its effect on children and the society as a whole. Dr. Patnaik has been vocal about the issue of data protection and right to privacy and has opined for an independent data protection body in India. We welcome you, sir.
Thank you so much, Pratishtha. Thank
Yes.
you so much to the, sorry.
Just final one important note that we would like to leave with all the participants. Please drop all of your questions in the chat box, and the same will be addressed at the end of the session. Now, without any further delay, I would like to invite Dr. Amar Patnaik. Thank you so much, sir, for being here with us.
Thank you, Pratishtha. Thank you so much for this particular session. Thank you to the committee. I think the seminar committee, that's what you call your committee as, who had sent the invitation to me. You know, the evolving story of the intermediary rules, which follows the guidelines which were earlier made in 2011, are actually have evolved, are evolving in almost a daily basis. We must realize the fact that we do not have a personal data protection bill as yet, or an act as yet in our country, even though the Honorable Supreme Court, as we all know in the Puttaswamy judgment, has already recognized privacy, right to privacy, as a fundamental right. Therefore, the right exists, right to privacy exists, but currently it is completely, left to the interpretation of the executive, to the interpretation of the courts, because we do not have a legislation. Once the personal data protection bill gets enacted, we will have a legislation in place supplementing this particular right to privacy, how it would be exercised, what would be the compelling state interests which it would also serve, and also would serve evidence-based policy making based on the data available. After all, we cannot let data be left unused, because the data is there for use for bringing about transformation in the society, for improving the lives of people, may it be in the field of agriculture or telecommunication or in irrigation or in whatever field. Therefore, we have to remember this. Why I am saying this is the context is very important. The context here is that we do not have a privacy bill, a personal data protection bill. We therefore the government had to, on prodding from what was already happening, rightly or wrongly in the social media space, and also on the prodding from the Honorable Supreme Court relating to self-regulations or some kind of a guideline for the OTT digital platforms, the government, I think, had no option but to come out with the Intermediary Guideline Rules 2011 under the IT Act, because that was the only act available. Many of the provisions in the new rules, one of the most important criticism has been the fact that it goes much beyond the rules. While this criticism may be fair to some extent, I can assure you that once the privacy bill becomes an act, you would find a great symmetry and synergy between these rules and the Privacy Act. Once the act and the rules fall in place, you will find that this particular gap or this particular criticism of the rules overreaching the provisions of the IT Act as alleged will subside. I have a feeling that the government, in its wisdom may have thought that it is better to have something by way of guidance rather than have nothing, and therefore they have come out with these rules and these criticisms. But once you have the bill, the privacy bill is already there in the open, in the public platform since 2019. The Joint Committee on Personal Data Protection, in which I'm a member, have gone through each and every clause and provision of the bill, and you will find a different, a kind of a finalized version of the bill addressing many of the concerns that have been raised by the critics when it finally gets introduced in the both the houses of the parliament. But now coming to the intermediary rules, let me say that broadly, the fight between the central government and the social media intermediaries. By the way, in the privacy bill, as also here, there have been thresholds for declaring certain category of social media intermediaries as significant data fiduciaries. In the privacy bill, there is a concept of data principal, that is, people whose data is taken, and data fiduciary, who is collecting the data, includes the person who is either keeping it for storage purpose or for processing purpose. Both are called data fiduciaries. There is a concept of a consent manager. I'm not getting into that, but all I'm trying to say is that once this act comes, you will see that things really fall into place, and there would not be much controversy as relating to the maintainability of some of the provisions in the IT rules. The broad criticism of the IT rules has been on the change in the operations for these social media intermediaries, because what it requires by way of regulation, by way of let's say content moderation, the requirement that content has to be moderated and brought down, so every content has to be checked. Now that requires a huge amount of change in the operations of these significant these intermediaries, and that would add to costs. So maybe that is one of the when we are operating in a space for about 10 to 15 years without any kind of regulation, this has come in as a shock, as something which is extremely stringent. But the benefit of this would definitely flow down to those who are affected by the abuse of social media. Our law is very clear. Our law is very clear that if the public policy in India is such that it tries to protect the interest of everyone, particularly the one who is the most poor and the most poor in the sense he may not be able to fight the might of the these social media intermediaries. Therefore, the requirement that content has to be seen and checked and brought down within once it is allowed to be or once it has been reported, then to be brought down within 36 hours. These are all to basically safeguard the interest of these social media users who are probably individually not powerful enough to fight the social media intermediaries themselves in terms of in their might. So this is basically to make the entire entire ecosystem sanitized. The argument of the social media intermediaries that this sanitization process should kind of be much more on the users rather than on themselves, which makes sense. But then it has to be both the stakeholders participating in this space to have responsibility, and the responsibility of the social media intermediaries is definitely, to my mind, much more. The second point is the cost of compliance being very high. The requirement in the intermediary rules that whatever I mentioned, and then also the another significant thing is tracing of the originator of information as against end-to-end encryption and penal liability for the chief compliance officer who may be prosecuted in his personal capacity for non-adherence to the due diligence requirements. Now, these are conditions which would impose costs, and that is what is riling the social media intermediaries. But then, for long, I can share with you that when I was in the committee and we were hearing all the, these representatives of these intermediaries, there was a unanimous feeling that the user is almost helpless against these big giants. And therefore, there was a need for regulation, and those regulations must protect against the test. The testing is test against the privacy ruling of the Supreme Court. The third point was relating to the user policies. That I think that's what again they feel that these are very stringent. I think the conflict, which as you very correctly said, that a number of things is already in the code of laws, various aspects. The traceability is in the code of law. Whether the retention period is also in the code of law. The appointment, many things are in the code of law. I'm sure they would be finally settled by the Honorable Supreme Court. But I also feel that once the privacy bill is passed in the Parliament, in both the houses, a number of these, gray areas would get settled, and even the court would understand the, intention of the legislature, which is making this act, which is very important for the purpose of the court interpreting the intention. The biggest point is of the fight between Twitter and the government is over this, that while the government says that everybody who has to operate here has to follow the law of the land, the rule of law includes privacy. The argument from the Twitter side, particularly, is the fact that we have our own privacy policy, and that is across the globe, and we think that that is more important. I think that is the crux of the problem, because they are multinational, companies, and their operations are across the globe. So they would probably look to the Universal Declaration of Human Rights. They would look for the international covenants, and that's what they refer to, say that to them the interpretation of freedom of speech and expression means something which is different from what the government is trying to tell them. But we must not forget that India is the largest democracy. Our institutions have been tested and time tested and well respected in the entire world. Particularly our judiciary is well respected, and therefore when the final word is there, comes out from the courts on these the rules, as well as maybe some provisions of the PDB Act when it gets passed, the acceptance of it internationally, globally, would be there. In fact, in the PDB bill itself, when you were talking about cross-country data transfer, then there is a talk of reciprocity and adequacy to see that whether those particular countries' regulations or rules are similar to the ones that we would have passed by that time for the data to flow. So slowly and slowly, we would be getting into a situation of a world in which the respect for privacy, the architecture for privacy, and the penalties for privacy violations and data breach would probably come to a common ground a common platform, may be passing through a process of bilateral arrangements and maybe multilateral arrangements, but ultimately, by the very nature of the internet, by the very nature of flow of information, which doesn't really gets attenuated by geographic boundary considerations, will finally find feet. There would be a uniform acceptance of what is acceptable as far as free flow of information is concerned, or freedom of speech and expression is concerned, and what would be considered as reasonable restrictions as given in our section 19.2 of the Constitution. And mind you, this section 19.2 reasonable restrictions are also very much a part of the fundamental rights. The argument made by WhatsApp that traceability would actually break the end-to-end encryption and may collect data which would result in loss of privacy appears sound, but the point is, my belief is you cannot have technology, you cannot have law to serve technology or subserve technology. You cannot have law to be designed in such a manner that it will promote that technology. We need to be in this world in which technology is a tool, and technology should in fact serve the law. Technology should subserve law. Technology should be able to promote law and rule of law. The question as to what is the rule of law by way of interpretation, which is what we have been debating, and that is what the narrative is all about, would eventually, I agree, would eventually finally get settled by the court of law. But I can tell you this, that once the act gets passed in the parliament, you will find that a lot of the gray areas go away, and some of these interpretations becomes easier. You could actually say that we do not, because the data protection law that we are going to have is modeled more on the EU GDPR, the European Union's GDPR, and is many experts consider as an improvement over that. Now, if it is an improvement over that, we may be having a unique piece of legislation which others in the world would follow, and then therefore a lot of these gray areas would get settled. As regards the accusation of liberal ideological bias by big tech companies and legitimacy of controlling free speech narrative, as I said, IT rules can be considered as a step in better regulation of such powerful companies, which hitherto were not being regulated at all. You may be aware that in the recent G7 meeting of the G7 countries, an unanimous decision was taken to impose a minimum tax rate, corporate tax rate of 15% in all these entities, which were hitherto enjoying almost in several parts of the world a tax-free kind of a situation. We in India still, in the Joint Committee on Data Protection, we were very curious to know from all these big tech companies as to what was their India operation, what was the size, how much of taxes do they pay, or what is the, currently there is no grievance mechanism. There is no grievance mechanism. If anybody is affected, there is no, and reports the matter, it is just completely left to them to decide in whatever manner they want. If someone is having a subscriber base of more than 40 crores, or that's 400 million, then it is incumbent on the data fiduciary to exercise certain amount of control on the kind of things that appears in the media, the section in its platforms. The argument that they follow to switch between the platform approach and the other one is relating to that we are a mere platform, therefore we have no control over who is posting what. And the other one is then in that case they have to behave like print media, where anything that comes gets published in the newspaper or whatever. They have to exercise that kind of a control. There are other issues relating to FDI in those cases. But if they have to, it has been known that the Twitter has taken down the tweets of Donald Trump. They have taken down the tweets of for a temporary period Ravi Shankar Prasad. Many places all over the world now they become a power unto themselves beyond the sovereign power of the state. I think this will become a monster if it is not regulated soon enough. The liberal ideologists like you and me would like to believe that we should give a complete free play to them. But mind you, we can't fight their might, leave alone those in the rural areas where they are also spreading. Social media is becoming a tool to not only improve communication between communities, but also it's a tool for accessing health, accessing education, accessing agriculture, knowledge about climate and weather, and so many other things, what have you. So therefore, I feel that the current tussle, the action which has been taken by the government, I may not agree with the approach taken. You see the High Court of Karnataka quashing the notice issued by UP Police against the Twitter's MD. The approach could have been much more consultative, but the need for regulation cannot be denied. There can be no true opinion about the fact that they cannot be assuming sovereign power above all our lives, the users of social media intermediaries. As regards the safe harbor, Section 79 of the ID Act, what happens to Twitter now? The social media intermediary who has not yet completely, been on board as far as appointing a compliance officer is concerned, is the fact that it loses people starting. That's the only thing that happens, that if people could start proceedings against them for what is appearing as content, as has already happened in terms of people filing cases against Twitter for CSAM, for wrongful display of women, and several such things. But then the point is, the basic element of the law, which is again, the Indian system, which is respected all over the world, would be the main sriya. That is, what is the intention behind it. So that again, the courts would finally decide whether the Twitter would be having some kind of a vicarious liability for people who are hosting this kind of content on its platform. The clarity would come once the courts start ruling. But I am once again, at the cost of repetition, reiterating that once the PDP bill comes, many of these areas, I can't disclose some of these because the bill is yet to be placed in the revised bill is yet to be placed in the parliament, and I, being a member of the committee, is bound by confidentiality provisions. Therefore, I'm unable to give very many details of it, but I can only say that many of these areas, gray areas, would get ironed out once the bill is placed. And once it is passed in the parliament, once again, it would still remain open for judicial review on many of the points that you and I may not agree. So it's an evolving field, and let us also applaud ourselves as Indians in the fact that we are not way behind as far as the global regulation is concerned. The UK's EU GDPR came in 2018 only. Many countries do not even have a full regulation, data regulation, though they feel the need for it. So we are well on track. We are looking at a very progressive legislation to come on board, which would not only safeguard the privacy of citizens, but also would promote digital India or digital economy, which is equally important, because if you have data of 130 crore Indians and we are unable to use it for their benefit, for their welfare, all of them not being personal data, I think we would be doing a disservice to the people of this country. Therefore, both the things are important, and this bill addresses this issue. I would like to end by saying that the social media intermediaries should also realize that they are they should not be looking at themselves as mere data fiduciaries, collecting a huge amount of data and shaping. They have the power now to shape people's behavior, people's and they have gone as far as to allegations of shaping people's voting behavior and other choices. But in order to build a world in which what would be important is using data for the benefit of world, using data for the benefit of people. Now, in this theme, it is not only the governments, but it is the social media intermediaries themselves who would have a most important and prominent role to play as the most important stakeholder. As long as they are very clear about this particular aspect and this overarching objective, I think the entire ecosystem would become better, and the regulations as well as the rules would become more acceptable to them as well as to the governments of those countries. I would end here and would now open the floor for questions, if any, and that would probably help me also to recollect some of the specific instances, if required, to buttress my arguments. Thank you so much.
Thank you, sir. Thank you so much for such a great insight. And I'm sure that your knowledge has given us a lot of new perspective to be aware of. And now, as you said, moving on to some of the questions that have been asked by the participants. One of the questions asks that, sir, do you believe that the compliance burden of the IT rules are not in favor of smaller digital entities?
It's a great question. In fact, that escaped my deliberation during my speech, though I had intended to speak about it. The smaller entities who are capable of giving a big push to innovation, big push to digital economy, big push to transformational changes in the way we do our business, that is, they trigger re-engineering of business processes in a completely different way. All these have to be nurtured. There's no two questions about it, no doubt about it. Now, for that, the compliance costs are too much. If the compliance costs become too much, these MSMEs, these small companies, they would not be able to survive. And therefore, it will kill innovation. And it would probably kill digital economy that all of us are, when we are providing rules and regulations, it is not just for the purpose of, a cohesive mechanism to stop certain things from happening. It is basically to promote something, to promote people's welfare through data in this case, or through use of data in this case. So the Personal Data Protection Bill talks about what is called as sandboxes. Now, once you have these sandboxes, regulatory sandboxes, what happens is that these small companies who are trying to innovate, they would probably be, the rules, the PDP bill as you see it, would allow these people to operate without following or without adhering to these compliances as much as is required for a big company. So these regulatory sandboxes have to be exploited. You will see when the bill comes that what you see in the current bill in the public domain and what you finally get, you will probably be pleased to know that its scope has been widened, maybe it has been allowed to operate in a larger space. You would also probably be happy to know that many such carve-outs have been made consciously by the members of the committee, which was well aware of the fact that the small companies required hand-holding, required less compliance costs for them to really innovate. And therefore, these carve-outs have been provided in areas or in sections which was not there in the public bill that you see on the, which has been released when it was introduced in December 2019. What you would probably finally see is a greater recognition of the needs of these small companies. And therefore, these carve-outs having been provided in many of the sections and provisions more than what has already been provided in the December 2019 bill.
Thank you, sir. So we have another question. So will the new IT rules result in overreach by the government to brand the content as against the public policy or seditions to suppress the dissent, or will it directly affect the freedom of speech?
Well, you see, the new IT rules or even the new Personal Data Protection Act will ultimately have to stand up to the test of judicial scrutiny as regards many areas, primarily the 19.2. That is, what are reasonable restrictions? Now, the reasonable restrictions mentioned in section 19.2 as a provision to the fundamental rights, section 19, a little more expanded version appears in the IT intermediary rules, and again a little more expanded version appears in section 35 of the PDP bill, which is going to become an act. So the point is, the argument of the government is that this is necessary for the state to function, to discharge its duty towards the citizens in situations of war and sovereignty of this country, foreign relations, and also required in situations like the current pandemic, where the health data of the people have to be taken without their consent. The IT rules, which have been prescribed now, as I said before, and I again repeat, they appear to be an overreach if you look at the IT Act under which these rules have been framed. But once the PDP bill comes, you will find a lot of these so-called appearing overreach clauses or overreach apprehension, move away or get washed away after the bill comes. The fear of the state using either the PDP bill or the IT intermediary rules or the IT Act itself to, let's say, the allegation that it will have more, it will exercise unauthorized surveillance, it will have greater impact on greater restrictions on the freedom of speech. These apprehensions and these allegations and these cases have always been there. You would see that even without the PDP bill or without the intermediary rules, there were always cases relating to what the sovereign thought as a reasonable restriction, but finally the courts thought that it was not reasonable restrictions. But the jurisprudence, surrounding the reasonable restrictions has been well settled now because of several of these cases. But there could still be gray areas because the way data can be used, the way algorithms can be used to infer data from raw data, that may not have been covered in the earlier judgments of the Honorable Supreme Court. But since we have such a robust judiciary with a very powerful tool of judicial review, which is well settled in law now, and the fact that this bill, because of the controversy surrounding it, will get discussed in threadbare detail in both the houses of the parliament across the party lines, I think by the end of it all, we will have something which is very objective, very narrow, very narrowly defined as to what are the areas in which there could be restrictions. And we could also have, my argument has been that India needs a surveillance law. Currently, the surveillance that is taking data from citizens without telling them, without their consent, is a completely executive process. The review of these decisions is also done by an executive process. Maybe we need a legislative backing for it and a law for it, in which case things would become even more clearer and more objective and less prone to abuse or misuse.
Thank you, sir. So there is another question by another user. So could you please tell us about the algorithmic bias that exists while targeting audience by social media intermediaries?
Yeah, so the algorithmic bias, there are two arguments on it. The argument by the social media intermediaries is that it's their business property, is business asset, and it's something which they are entitled to use to further their business, and therefore no one could have privy to such algorithms. But a broader argument, contrary to such an assertion by these social media intermediaries, is the fact that public interest and citizens' interest is paramount, and whatever is done with that data, whatever inferences would be drawn and would be used, should also be told to the data principal, to the citizen, is an overarching argument too. And that is the argument that has been taken in the Personal Data Protection Bill, that the data collector or the data fiduciary, while collecting data, has to mention for what kind of purpose for which, that's the purpose limitation, what kind of purpose it will be used for, what is the purpose it will be used for, the inferred data, how will it be used, as far as personal data is concerned. I'm not talking about non-personal data. So these algorithmic biases are there is no doubt. In some countries, in the EU, these algorithmic content, the algorithms in themselves are regulated. And therefore, there is some kind of a regulation to how the people's data would be manipulated. But there is an argument again against that it would kill business enterprise, it would kill business innovation, because that's essentially is their commercial decision, that essentially is their commercial capital, the whatever they are spending in R&D in a normal company, bricks and mortar company, is exactly what they are doing to develop these algorithms. But that these algorithms can also be tweaked to shape the choice of citizens. Therefore, some kind of regulation may also be required there. So our Personal Data Protection Bill, I hope, would address this in a very, very soft way. If you make it very stringent, I'm afraid it would actually be a negative fillip to digital economy, growth of digital economy.
So another question here asks that the parent legislation had never any kind of regulations over the news media outlets, but the new regulations does. So do you think that by doing that, the new IT rules are taking on extra powers in its domain and kind of overarching the jurisdiction of the courts or maybe the other entities?
So that's right. In fact, I mentioned about it in my speech, that the way the current IT intermediary rules have been framed, they appear to be actually overreaching the IT Act 2000, because they've been framed under IT Act 2000. But having elements of privacy in it taken from the privacy law. Once the privacy law comes, the IT Act 2000 and the privacy law will complement each other. And then I think many of these gray areas would get sorted out. The OTT platform issue is taken under a separate act, the Broadcasting Act. But in the privacy law itself, there is, I think, Section 36, Clause E maybe, which talks about, the people who are operating these digital platforms, they also need to be regulated. Just like the print media is regulated by the Press Council of India, there has, and this is a prodding. Electronic media has to be regulated. This prodding is coming also from the Supreme Court of India. So the Broadcasting Corporation of India, similar to that, some self-regulating body, if it is created and makes its own codes and practices so that the operators will follow that, then that particular would be the guiding principle. And such provision is mentioned in the PDP bill itself. So it is a regulation, but it is a soft touch regulation and a regulation made by they themselves with an overarching government's theme. Government comes in when the self-regulation fails. So these IT intermediary rules, I look at them as very temporary, addressing the temporary problem of the seeming takeover of the individuals, citizens' lives by these social media intermediaries to address that issue. I don't understand who could have a problem if there is a grievance mechanism set up. When we were bureaucrats and things should be written against us in newspapers, we used to complain to the Press Council of India. The Press Council of India invariably, and that's a body which has been set up as a self-regulating authority, which would invariably examine the issue and take a call, and that would be binding on both. Now, similar such arrangement is not available on the electronic media and on the digital platforms. The idea is that once they have this and they put in place their code of ethics, that is what is going to be respected, and that will provide the regulatory cover to their operations. So currently, as it seems, yes, it looks as an overreach, but I have a feeling that it will all sort out once the other bill comes. Thanks to the recent data breaches that have taken place all over the place, and the latest Pegasus incident, the need for a data protection law is cannot be overemphasized, and rather cannot be this is the most opportune moment, and everybody realizes that across the party lines that there is a need for this law to come in. And once that comes in, I think many of our, once again I repeat, many of our issues would get resolved.
Thank you, sir. So there we have another question. This user is talking about the second rule, which talks about the identification of the originator. And this particular user has wants to know about your take on the constitutionality of this provision, as they feel that it has chilling effects. This second rule has chilling effects on the freedom of speech and expression.
So you see, the my take on this is that, first of all, freedom of speech and expression is a fundamental right, but it's not absolute. Will have reasonable restrictions. These reasonable restrictions are imposed by the state, by the executive, are subjected to judicial review. But in the case of traceability or the originator of a message, the point is, it is not going to happen in all cases. Only when there is an investigation, the enforcement agency wants to have it, or the executive wants to. Enforcement agency is a part of the executive, by the way, or the normal executive wants to have it because of the threat to sovereignty, whatever. Then only the originator of the information, originator of the messaging, if it's a WhatsApp, it's a WhatsApp, if it's Signal, whatever, will have to be provided to the enforcement agencies. In fact, being from the bureaucracy, I feel that, and they do talk to me, and many of these enforcement agency senior officers, that even the fact of knowing the originator actually doesn't serve the purpose of law as much as people make it out to be. For completing an investigation, even the content is important, as to provide or to place it as evidence. Now, the originator you assume the situation if it is not the WhatsApp application. When there is a let's say crime committed in somebody's house, the police, by way of its regular investigation, if there is an accused, gets the CDR of the accused mobile phone. And once it gets the call data record from the service provider, it's again going and getting this information from there. Isn't it also, this can also be said to be a breach of the freedom of privacy, the freedom of expression, because the accused whose data the service provider is keeping, the mobile phone service or basic telephone service provider, who is keeping the data record, call record data of people. Amongst those people is an accused, or there are 7 or 8 people who are supposed to be accused, then the police has access to them. The law is currently allowing that. They do happen. In this case, it is this particular message is coming through a series of people. It's end-to-end encrypted, therefore you do not know who it is coming through. But if the enforcement agency does not have access, then how will it solve the crime? There are questions. There are people who say that such kind of crimes happen only 1% or 1%. Why should you compromise the privacy of the rest of India? Very valid argument. But our law is very simple. Our law is to protect that single individual's privacy, that single individual's right to a fundamental right as well. It is his fundamental right to get justice. Excuse me. And therefore, it has to be respected. Now, the courts will only decide what is an overriding public interest, which can probably override this particular individual's right to get judicial remedy.
So another user asks, data technology and its uses diversify quite rapidly. So how can we tackle this need for constant upgradation of policy in order to keep up with the technological changes?
That's a good question. Very good question, because no amount of regulation can catch up with the technological changes. Technology would always be ahead. But this question of yours is not about regulation. This question is, how do you upgrade your knowledge to make use of these technologies or make use of this data for policy, for public, for formulating policy, delivering policy, and for the public good. No, it is not a question of, it's not a challenge really. It's not a challenge in a negative sense. We should allow technology to flourish, blockchain, AI, MCL. In fact, it is the human ingenuity now, how to make use of this technology for public good, for delivering public good. In the Indian context, it would require, the Niti Aayog comes out with, it has put in the public domain, I think, a policy on use of AI. I am a firm believer that we are very slow in adopting blockchain. You can see my articles recently also in the Queen. There are several areas where we could actually use technology for better policy making and better delivery of policy, and that is not happening. So there is a lot of work which is required to be done in order to take advantage of what technology allows you in public policy making. Merely mentioning it in section 91 of the PDP bill that the data will be taken by the government without taking consent for evidence-based policy making sounds good, but in policy making in India has largely been whimsical rather than evidence-based. This gives us an opportunity. These times gives us an opportunity to really make use of data for better evidence-based policy making. If we do that, then we will have better simulation of or modeling of, let us say, a cyclone, a disaster, or an agricultural operation, even a health pandemic, targeted delivery of services, to even eventually have a better way of, let us say, handling a crisis of any kind. We would be actually missing all that if we do not use technology's power in policy making. I think we need to do a lot in this area.
So one final question we have. Current PDP rule bars significant data fiduciary STF to target audience. Do you think the payment gateway to these STF will also be STF, for example, FAMPay?
Current PDP rules, there are no rules currently on personal data protection. You mean to say, is it the IT intermediary rules? And it is a significant data fiduciary. The data fiduciary, significant data fiduciary, these terms have been used in the PDP bill. It has not yet become an act. But I get the sense of what the question is. Yes, the point is anybody who has collected the data or who is using that data to process that data, and after processing it is also storing some data, all these would be considered as data fiduciaries. And out of this, there are various criteria on which some will be considered as significant data fiduciaries. Anybody who is handling the data after it passes out of the data principle, once it has been collected in whatever manner, would be considered as a data fiduciary by definition.
All right. Thank you so much, sir. So now we would like to invite our convener to extend with the vote of thanks. Thank you so much, sir.
Thank you, Pratishtha. It's an honor to have been asked to offer vote of thanks. I, on behalf of Seminar Committee of Dr. Ram Manohar Lohia, National Law University, and on my personal behalf, extend a very hearty gratitude to our guest speaker, Honorable Member of Parliament, Dr. Amar Patnaik, for sharing his wisdom with us today on one of the most contentious topics in contemporary scenarios. It has been a privilege to host all the members and audience of the meeting. I am thankful to all the participants for their patient listening and hope this insightful session has brought much clarity in their minds regarding the topic. Well, we are very fortunate to have personality like Dr. Amar Patnaik with us, who has numerous contributions, especially in the field of information technology and data privacy. And also, he's one of the best intellectuals this country could have. Thank you for your presence, sir. We would love to host you in college as soon as the pandemic situation is resolved.
Thank you so much. Thank you. Thank you. All the best to all of you. And in any case, if you want to contribute to have any kind of conversation, any of your students on this area, they could get in touch with my team, because I think this is an evolving field. This will continue for a long time. Let me part by saying that once the PDP bill gets passed, it will be an act. But remember, in the provisions of the PDP bill, there is a huge responsibility with the Data Protection Authority has to come out with regulations, and that is a huge job again. And after the regulations comes out, the state or the executive will come out the rules again. So that's again another huge job. So a lot of work is required to be done, and this is almost like an overarching legislation, which I say in independent India could be one of the most significant umbrella legislations that India would be having. Thank you. Namaskar.
Thank you, sir.